Hi everyone, I am Dr. Vijay Kumar Singh and I am your instructor for few of these courses on other laws. Today we are going to cover the topic of the General Clauses Act 1897 under the topic corporate and other laws of your paper 2. These are live virtual classes of Board of Studies of ICAI. General Clauses Act as such, when we talk about, is a general legislation which applies to all central legislation. And we are going to cover that. It is important legislation as far as interpretation is concerned, because whenever you will be getting a situation of interpreting a legal provision, this law becomes handy if there is an interpretation question. And I will lead you through that discussion. I hope you are having the remaining instruction about the questions, how to ask the questions, and how you will get these particular materials on your portal. Now, moving forward, when we talk about this General Clauses Act, the General Clauses Act is a central legislation, as I told you before, but there may be state legislation also on General Clauses Act. And if there is a state legislation, then state legislation makes a precedence as far as the state laws are concerned, or interpretation of those state legislations are concerned. For example, in Karnataka, you have this Karnataka General Clauses Act 1899. Now, moving forward, there are certain objectives of this course or this chapter or this session. And we expect that at the end of this particular session, you should be in a position to explain the purpose of General Clauses Act. And you should have some basic understanding of the legislation as to how this law is arranged and what is the purpose of this legislation. You should be able to, define the provisions under this act. There is a general definition section under the law, which you need to define. Identify general rules of construction. We are also going to have 2 more sessions on interpretation of statutes, where we are going to go specific about the principles of interpretation and different aids of interpretation or construction. But General Clauses Act also provides certain norms for interpretation of legal provisions. So we will talk about that as well. And then explain the powers as to orders, rules, etc. made under the enactments. And you should be gaining knowledge of other miscellaneous provision under this law. So with this background, we will begin with the General Clauses Act. I always suggest the students to have a look of the Bare Act at least once. Bare Act basically means the actual legislation without any supplementary interpretation over it. Nowadays, if you look at the Bare Acts, you also get along with the Bare Acts certain decisions along with the particular sections. So these are important decisions which are mentioned in the Bare Acts. It depends that which kind of a Bare Act you are taking. There may be some brief commentary also about the section or the clauses. If you have an overview of this particular legislation, the General Clauses Act is having these sections. So the first section is preliminary section with section number 1. There are definitions which are provided in section 3 to section 4A, that is the general definitions. There are certain general rules of constructions which is there in section 5 to 13. And there are certain powers and functionaries who have been mentioned and which apply in case of all central legislations, that is section 14 to 19. And there are certain provisions as to orders, rules, and enactments in section 20 to 24. And there are some miscellaneous provisions from 25 to 30. So our aim today is to cover all these 30 sections. And if something remains, then we will carry it forward in our next session. Moving forward, this is the arrangement of the sections as you are able to see in the law. This is the cut short, screenshot for understanding the different sections. So as I told you the arrangement before, it begins with preliminary. Then there are general definitions, then general rules of construction, powers and functionaries, and provisions as to orders, rules, etc. And then miscellaneous provisions are there. And then there is also a schedule, but this schedule has now been repealed. Previously, this schedule was there under this legislation. So you don't have to go to the repealed sections, but just for your understanding, you should know that there was a schedule here which got repealed. Now let us understand what is the objects and reasons of General Clauses Act, why this legislation is important and why this features as a, thing for your subject and why you are supposed to read this law. So if you see the interpretation of statutes such as the General Clauses Act are intended to set standards in construction of statutes. So objective of this law is to provide some standards of interpretation. So whenever you look at a central legislation, there is a way of looking at the provisions, there is a way of interpreting those provisions, and General Clauses Act provides that kind of an interpretation. Secondly, the expression when you talk about construction, the construction is very, very important. So when you talk about construction, it is oriented towards understanding the text of the statute, to understand the true meaning of the words and what is their intention. Many a times when you look at the legislation, when you look at a legal provision, it appears to be very clumsy, or you can see it appears to be very confusing. Many a times repetition of words you find, and this is basically legal language. To understand that legal language, many a times you require some support, and General Clauses Act provides that kind of a support. So apart from setting the coherent and consistent methods of understanding enactments, the interpretation of statutes also subserve the purpose of reducing the prolixity of legislations. That basically means that if you are able to interpret the provisions properly, you are able to apply the provisions properly, then there is no need for multiple of litigations, because most of the litigations arises because there is some problem in the legislation or there is an interpretation issue. I can give you an example. Like, for example, under the Competition Act, there used to be a provision of turnover, right? And the confusion persisted that whether it is a relevant turnover or it is a total turnover. And this question was, deliberated by the Competition Commission of India. And it said that no, it must be the total turnover, because this is a deterrent provisions. Then it went to the appellate tribunal, where it said that no, it has to be the relevant turnover. And then again, it went till Supreme Court, where it was said that no, it is relevant turnover. So you can imagine there were so many litigations on which hinged upon the interpretation of this clause. So it is very important that interpretation and construction of clause is proper, so that anybody who is utilizing that legislation is without any confusion. So that is the major aim and objects of construction of a statute. So the General Clauses Act lays down certain standard principles, which is formulated to do interpretation, and they must be read into any and every enactment falling for consideration. So if you look at this is a decision, this is a clause which comes from a decision. It says in the ultimate analysis, interpretation statutes or definition in interpretation clauses are only internal aids of construction of a statute. And who are they helping? They are helping basically the courts. So interpretation is domain of which body? It is the court which actually interprets the laws. Can we interpret the law? Yes, we can interpret the law, but that has to be always subject to court's interpretation, right? So you always, that is why, look for the different decision or the court orders as to what they have told in a particular case. And that is how you can see there are a lot of case laws which you people have to read to understand that what court has said on this issue. And hence, this construction of General Clauses Act and application of General Clauses Act to a particular provision is the domain of legal interpretation. So you people are taught this particular topic because many a times there will be a situation where you have to come across interpreting a term in a statute, and then you will go back to the decisional practice of the court and try to find out what courts have said in this. And many situations you will find that courts are referring to the General Clauses Act. So this is something which was held by the court or court observed with reference to General Clauses Act in Pernod Ricard versus State of Madhya Pradesh. This is a 2024 decision of the Supreme Court of India. If you are interested to read more on the General Clauses Act and its interpretation, you can also refer to Law Commission of India report, that is 183rd report, which discussed about the General Clauses Act, a continuum on General Clauses Act, and it provides for some background of this law and where it stands now. So that is a very good literature. If you are interested in additional reading, which I always suggest to the students, that additional reading always helps you in subjective papers. So it will be useful to you. In case you are interested, you can go through the Law Commission of India report also here. Now let us go ahead and understand what is the object, purpose, and importance of the General Clauses Act. So if you look at the preamble of the General Clauses Act, it talks about the objective. Its statements and objects and reasons also provide for the objectives. So one of the objectives or the purpose of the legislation is to shorten the language of central acts. So just imagine whatever provisions which are mentioned in General Clauses Act, if there is a requirement to put all these clauses again and again in all central legislations, the legislations will become bulky. So the General Clauses Act provides for the general definitions, general understanding of the law, how it has to be constructed, and hence General Clauses Act provides a supportive kind of an environment to the different central legislation. So it shortens the languages of central act. This is one of the primary purpose. Second is it provides as far as possible a uniformity of expression in central acts by giving definition of a series of terms which are for common usage. Like say, for example, there is a definition, if we look at it, of the word swear, or maybe of the word vessel, or maybe of the word will, then these definitions under the General Clauses Act would be not repeated again in the central legislation. And if you have to see the meaning of these words, you can just refer to the General Clauses Act. That is sufficient. So the interpretation of a term from one legislation to another legislation will not vary because there is a common definition given under the General Clauses Act. So this is one of the another important purpose of the General Clauses Act. The third purpose is to state explicitly certain convenient rules for construction and interpretation of central acts. So as I told you in the part, second and third, where we are talking about different rules of interpretation or construction that has been provided in the General Clauses Act. And further, to guard against slips and oversights by incorporating or by importing into every act certain common form clauses, which otherwise ought to be inserted in every central act. So if there are chances of errors that there are more than 1100 plus central legislation, in every legislation, if you have to import this particular definition, probably in some of the legislation, there may be a grammatical error or omission. To avoid that also, this General Clauses Act helps. Now, the purpose of this legislation has also been laid down in one of the cases, that is Chief Inspector of Mines versus Lala Karamchand Thapar in 1961. Supreme Court dealt with it, and it said as follows. It said, the purpose of this act is to place in one single statute different provisions as regards interpretation of words and legal principles, which would otherwise have to be specifically, separately in many different acts and regulations. The purpose of the act is to avoid superfluity of language in statutes wherever it is possible to do so. And whatever General Clauses Act says, whether as regards to the meaning of the words or regards to legal principles, has to be read in every statute to which it applies. So this is the overall objective of the General Clauses Act. Now, if we look at it, this dimension, this tells us that General Clauses Act is, for understanding of the central legislations better, right? Yes, I can see in the chat box somebody has written, if I can explain it in Hindi. Now, Pawan, this particular session is in English medium, and since students come across all over India, the medium is kept English here. So we speak in English. I will try to, answer your questions. Maybe during the question answer session, you can ask me the things, and I will try to answer you in Hindi. Okay. Now let us come down to an example of interpretation. And when we say about interpretation of words is very important in the legal field. So you have to understand the interpretation part of it. And I will give you one example. Like, say, for example, in one of the cases that was relating to the SARFAESI Act, there was a question that whether the appointment of an advocate to take possession of secured assets can be done by a advocate appointed by the district magistrate or chief metropolitan magistrate. So if you will see the provision under the SARFAESI law, it talks about district magistrate and chief metropolitan magistrate and its officers or its officials. So here the question was, here the DM and chief metropolitan magistrate appointed an advocate on behalf of them to take custody of the property. And this was considered, this was challenged in the court, and court said that this is not proper because the statute says that it should be the DM or CMM or his any officers to whom it is designated. Advocate cannot be there. So here the Supreme Court discussed the subordination aspect of it, and it said that there is something which is called functional subordination, and this functional subordination requires that the delegation can be done. It is a common knowledge that respective jurisdiction there is only one CMM and DM, and if you make it mandatory that only the DM or the chief metropolitan magistrate can only take possession of the assets, then in that particular situation it will be difficult to implement this provision, and hence purposive construction was done in this particular situation, and it was said that okay, fine, if the advocate is appointed on behalf of CMM and DM, because advocate is just taking action on a decision already taken by the DM and CMM. So decision is not taken by advocate, but action on that decision is taken by the advocate, so it can be permitted. So this is what was the interpretation given in this clause. So what I'm trying to tell you is that there will be interpretation requires to work in context. So there will be situations, and in that situation there will be an interpretation of the term which will be carried out where there is a vacuum. But here you have to understand that if there is something which has been written in black and white, अगर वो काले अक्षरों में लिखा हुआ है तो उसमें कोई फेर बदलाव नहीं किया जा सकता है. There cannot be any change in that particular wording of a statute by way of interpretation. So interpretation only comes into play when there is a confusion. If there is no confusion, statute is very clear, then there is no question of referring to interpretation. Similarly, it goes with General Clauses Act. So if your statute or the central legislation which you are referring to, for example, IBC or Competition Act or any other legislation, then if those provisions are very clear, there is no need to go to any of the interpretation clauses or any of the clauses of General Clauses Act. But if there is a confusion, if there is a question which requires further answers, then a reference can be drawn to General Clauses Act or maybe to any case law or any other interpretation. I hope this basic principle is very clear in your mind, because this is very important. This is the basic principle of interpretation which you should keep in mind. So you cannot change the express provision of law by way of interpretation. It is only the parliament which can change it, or in certain situations, Supreme Court can lay down a law, or you can say interpret that particular law in a particular fashion, or it can lay down a guideline under the Article 142 of the Constitution. Now, if we talk about it, this example was from the case of NKGSB Cooperative Bank versus Subir Chakraborty 2022 decision. A very important decision for CAs as well, because nowadays we are talking about insolvency laws, and under the insolvency, this particular law was taken into consideration. Now let us understand, because we are talking about interpretation, so it becomes very important and imperative that you understand what is law. And Article 13 of the Constitution of India defines law. And if you see Article 13(1) says, all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of Part 3, that is fundamental rights, shall be inconsistent or will be void. If they are inconsistent, any of the legal provisions which are inconsistent with the fundamental rights under the Constitution will be void. This is Article 13(1). Article 13(2) talks about the situation that if state is making any law, state includes here, the state here means sovereign, which includes the central and the state government, as well as municipalities and local government. So if they are making any law, they have to be conscious that their law does not breach the fundamental rights. If any of these law will breach the fundamental rights, there will be a requirement of challenging the constitutionality of this particular law. So there will be a challenge to constitutionality of that particular provision, and that may be struck down by the Supreme Court. Now, Article 13, subclause 3 defines law, and it says that in this article, unless the context otherwise requires, the law will include ordinances, orders, bylaws, rules, regulations, notifications, customs, or usages having the force of law in the territory of India. So let us understand it by a very simple example. For example, ICAI is a body which has been constituted under the law. You people all know that particular legislation. And now if ICAI frames some regulations to regulate the conduct of the chartered accountants, then that itself is a law, right? So you have to understand that this is law, and that is as per the definition of law under the Article 13. However, this law cannot infringe the fundamental rights of the people. Like there cannot be any discriminatory provision or discriminatory regulation. So this is what the definition of law tells us. Then there is something which is called laws in force. This is important. Laws in force. So there may be law on paper, but the law may not be in force. Like for example, if I give you example of Competition Act got enacted in 2002. But the law got into force only on 19th May 2010, if I am not wrong. So 2009. And some provisions of combination only got notified in 1st June 2011. So the different provisions of a legislation may not come into force on the same day. The government may choose to bring certain provisions on certain dates. And that is what is laws in force. So laws may be on statute, but law may not be on force. So it is very important to see whether the law which is enacted or which has been passed is in force or not, right? So it is very important that provision where laws in force becomes important. Now I want to give you some example, and this example is with reference to the definition of immovable property. So this is an example. So whether fish is an immovable property, what do you say? You can use your chat box to respond to this question. What do you think? Whether fish is an immovable property or a movable property? There's a picture also which you are able to see here. So what do you think? It is a movable or an immovable property? Okay, fish is an immovable property. Good. Oh, yes, Khushi says immovable property. Very nice. Yeah, most of you have answered movable, but okay. Now this is the question. So immovable property is basically not defined. If you see in Transfer of Property Act, there you get the definition of immovable property. So Section 3 of the Transfer of Property Act does not define the term immovable property, except to say that immovable property does not include standing timber, growing crops, or grass. As to fish, they do not come under this particular category. So now there is a question. How do you find out whether it is a movable property or immovable property? So you go back to General Clauses Act. And in the General Clauses Act, there is a definition under Section 3, subclause 26, and it reads as follows. It says, immovable property shall include land, benefits to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. So if you see permanently fastened to anything attached to the earth would include even machineries and plants which are permanently attached. So they will be part of the immovable property, right? So say, for example, there is a building. So building is part of that particular immovable property. It is not a movable property. Here, in case of fish, though it may appear that it is a movable thing because this fisherman you are able to see is able to carry that fish, but fish is considered as a profit appendre, right? So profit appendre basically means a right, legal right, allowing a person to extract something of value from another's land. So it is regarded as a benefit arising out of the land. It follows that it is an immovable property within the meaning of the Transfer of Property Act. So you can see how, by way of an interpretation, a fishing right or a right to transfer of fishing rights is considered as an immovable property. And this you must be seeing as a chartered accountant. You will come to know the fishing rights is taxable rights, and many times fishermen get patta to fish a particular pond or a land. Why that right is a immovable property, right in immovable property, and not a right in movable property. This is what Supreme Court interpreted this in Anand Behera versus State of Orissa. So you can see I just tried to give you an example how General Clauses Act is utilized for finding out a definition which you could not find it in the main legislation. So the court constitute right to catch or carry fish as an immovable property in this particular case. I hope this clarifies. Many congratulations to the people who answered it as immovable property. And for the people who answered movable property, nothing to worry. This is something which is, a thing which you are learning. So it's fine. So when you say profite pendre, basically it is a legal right which is given to a person who can extract something or value from that particular land. Like say, for example, a value of extracting the mines or extracting the minerals from the land. That is also a profite pendre, right? So this is the example. Now let me take you forward to the another example. Okay. So before I proceed, let us move about and talk about application of the General Clauses Act. So Section 1 of the General Clauses Act says this act may be called the General Clauses Act 1897. And you will see there is something which is called the commencement of the law. And any legislation, whichever you see, you will find that there is a short title and commencement. In your General Clauses Act, the commencement part is repealed. There is no requirement of the commencement part because it has already commenced a long time back and after independence. So this clause has been already deleted in 1914. Probably it got deleted, omitted. And I have given you just an example of Bharatiya Saksha Adhiniyam as to how short title application and commencement provisions are there in other legislation. So it is just for an example. You can see here, in case of Bharatiya Saksha Adhiniyam, it is written like that, and then it applies to which proceedings that is mentioned, and it will come into force on such date as central government may notify. And you people must be aware that 1st July 2024 was the date when the Bharatiya Saksha Adhiniyam, BNS and BNSS came into existence. And 1 year now, yesterday we completed 1 year of these legislations. So application of General Clauses Act does not mention anything about that. So it is not there. And if you see General Clauses Act, it can also be utilized for interpreting the Constitution, right? So Article 367 of the Constitution of India authorizes use of General Clauses Act for the interpretation of Constitution. So Article 367 goes like this, and it says, unless the context otherwise requires, the General Clauses Act 1897 shall, subject to any adaptations and modifications that may be made therein under Article 372, apply for the interpretation of this Constitution, and it applies for the interpretation of an act of legislature of the Dominion of India. So this is what they have mentioned. So this is a pre-British, pre-independence legislation which still applies to us. Now, if you see the act applies to the act which is passed by Indian Parliament, it also applies to the act of the Dominion legislature. Dominion legislature refers to the Indian Dominion prior to independence under the Government of India Act 1935, and acts passed before the commencement of the Constitution by the governor, right? So all these particular laws will be governed by this General Clauses Act. For you people, you can refer to the other two parts. It is now history and not much in use now, but acts of the Indian Parliament are still governed by the General Clauses Act. Now, I just wanted to give you a brief understanding of a legislation also and how to read the legislation. I told you that you should have a brief idea that how the legislation is arranged. What are the major things which you should focus and concentrate when you are looking at a legislation? This will be also useful to you when we go and try to understand how interpretation works. Okay. So if you are seeing this legislation will show on the top of it Gazette of India. So all our legislations are published in the Gazette. And once it is published in the Gazette, that means it is notified for the use of the all public. And on the top, you are able to see New Delhi, and this is the place where it is published, as well as it tells you the date of the publication. So it gives you the date, and you are able to see here the date is in both Gregorian calendar as well as our Hindu calendar. So if you see here, there is, Shravan 1945 Saka. So that is what the calendar is mentioned here. By the way, for your information, Nepal follows only the second calendar. So in their official calendar, you will see they are following only this particular calendar. We have here in our situation, we follow both the calendars. Officially, both the calendars are mentioned in the statute. Then you will see on the second part, you are able to see the ministry, that is legislative department has come up with this particular legislation. In most of the cases, you will find like that. And then you will see the date when president gave assent to the legislation. So that is the date when president approved this legislation. That is 11th August 2023, which you are able to see here. And following that, there is a title of the law. So the Digital Personal Data Protection Act 2023 is the title of this particular law. In the bracket, you are able to see number 22 of 2023. That means this is the 22nd legislation of the year 2023, right? So this also gives us an indication that it must be somewhere in between or towards the end. So you have to see how many legislation passed in 2023, and accordingly you can make out. Moving further, there is something which is also important, Section 5 of the General Clauses Act, which comes into picture here, which is about enforcement, right? So the question is, the president gave an assent to this legislation on 11th August 2023. And actually, when it came into force, do you think Digital Personal Data Protection Act is already into force? It is not, right? The rules have already, public consultation has been done on the rules and regulations, and it is yet to be notified for implementation, right? So it is not in force. So when it will come into force, and what should be the procedure for doing it? So there is something which is provided about this in Section 5 of the General Clauses Act, and it says coming into operation of enactment. So let us read this provision. What it says? It says, where any central act is not expressed to come into operation on a particular day, then it shall come into operation on the day on which it receives the assent of whom, or in case of central act made before the commencement of the constitution of the Governor General, and in case of an act of Parliament of the President, right? So this is where it has to be specifically said that this will come into force or it will come into operation on these two dates. Second, unless the contrary is expressed, a central act or regulation shall be construed as coming into operation immediately on the expiration of the day preceding its commencement. So this is important, so that when do you think the commencement will start? So I think that you have a problem-based question on this part. Unless the contrary is expressed, a central act or regulation shall be construed as coming into operation immediately on the expiration of the day preceding its commencement, right? So say, for example, you are saying that the law will commence. Let us take the example of the previous one. You are saying 11th August 2023. So when the law comes into force, immediately after the expiration of the day preceding its commencement. That means what? It will commence on what time? It will commence on 10th itself, right? So 10th after 12 p.m. in the night, it will, start commencement. The law will commence. And that is what exactly happened in case of the your Bharatiya Nyaya Sanhita, where 1st July 2024 at the stroke of the midnight, the law was, allowed to be operational. So this is what it says. In blue, in the slide, you are able to see there is something which is called presumption against retrospectivity, right? So it is very important provision. No law can go retrospective unless it is specifically mentioned in the legislation. So there is a presumption against retrospectivity. So there is a presumption that all laws are prospective. They will be applying in the future date. So if the law is applied on 11th August, it cannot take into consideration situations which has happened in January. So it is not a violation of a provision if something has been done in January, unless there is a specific provision with reference to that yes, it will apply to with a retrospective effect. Generally, in case of taxation statutes, there may be some provision which can go retrospective, but most of the times it will not go. General presumption is that the law will be not with retrospective application. Okay. So this is a thing which has to be mentioned clearly. No, Companies Act 2013 is not a retrospective act, Rajveer. It is a law, all provisions which came for the first time, like say, for example, CSR provisions. CSR provisions came in Companies Act 2013 when it got notified. So CSR provisions cannot be, applied with a back date. So it is not retrospective application. However, there are certain provisions which are same, which keeps continuing in future also. So say, for example, 1956 Act has provision relating to independent director. 2013 Act also had the provisions relating to independent director. So they are same provisions. So they continue. So that is why there is no question of retrospectivity or prospectivity there. But generally, the acts will not be applying with retrospective provision. So Supreme Court in A.K. Roy versus Union of India observed that when an act empowers the government to bring any provisions into operation on any day which it deems fit, no court can issue a mandamus with a view to compel the government to bring the same into operation on a particular day. So it is very important provision. So many a times government delays the application of a particular law, and nobody can direct or issue a mandamus. This has happened in case of, if you would recollect, this is about delimitation exercise or application of women reservation in case of women reservation bill, which is yet to be applied. So many people have moved Supreme Court for issuing of a mandamus. So the law is there. Supreme Court has already said that you cannot compel the government to implement a law on a particular date immediately, right? So this is an interesting point here. I am not talking about another important point which you people may have read as a general awareness. This is with reference to the assent given by the governor to the state bills. That is a different controversy altogether. We are not touching it here, but I want that you people should be aware about it. So you can read it on your own. The decisions that within a time bound period, the governor has to take a call on the legislations, referred to it by the state governments. Well, now let me proceed further and we talk about the other part of the legislation. I was telling you the structure of a legislation, how the legislation is arranged. Okay. So these are some of the examples. As I told you before, that there may be questions which can come to you. So these examples are mentioned in your course material. Like Companies Act 2013 received the assent of President of India on 29th August 2013 and was notified in the official gazette on 30th August with the enforcement of Section 1 of the Act. Accordingly, the Companies Act came into force on the enforcement date of its publication in the official gazette. Similarly, in SEBI, ICDR 5th Amendment regulation was issued by SEBI on notification dated 14th August with effect from 1st January 2016. Here, this regulation shall come into force on 1st January 2016 rather than the date of its notification in the Gazette. Okay. So this is how we have to see. Now, if you will see, the legislations have got something which is called preamble. So all legislation begin with a preamble. Preamble sets the tone of the legislation, and we will talk about it, what is its value in interpretation in our next session. But there is a preamble. In all legislation, you will find a preamble. Generally, you will find a preamble in all legislations. Then there is a short title. So short title of the legislation is just like this, the Digital Personal Data Protection Act. That is a short title. Then in section 1, there is also a provision which talks about commencement and extent of application. So this section or this subclause tells you that when the law will come into force and what is its extent of application. Previously, this extent of application was important because Jammu and Kashmir was to be excluded in most of our legislations. But now after Article 370 abrogation, these provisions are not required. So it anyways, commencement means it applies to all over India. So this is commencement and extent of application. And in most of the legislation, you will find that there is a definition clause. So you find a definition clause wherein the definitions are given. So you can read these definitions. Okay. So Soumya, when we talk about writs, there are different writs which the court can give, and mandamus is one of the writs, one of the 5 writs which can be issued. Mandamus means order to comply. So generally, whenever a government or whenever a government authority is under an obligation to do a public duty, they don't do it, court can order to do that particular thing. Say, for example, you applied for a passport and you are eligible to get your passport and you have been denied your passport. You can file a writ petition in the court. Court will issue a mandamus to the authority to issue you a passport. This is what is called mandamus. I hope that clarified your understanding about mandamus, right? Now, let me move further. And if you see if there may be words which are not defined in the definitions of the Act, the meaning of such words may be taken from General Clauses Act, as I told you before. So remember that General Clauses Act only comes into picture when you don't have the interpretation or when you don't have a specific definition of a term in your own statute. If you have a definition of the term in the statute, then there is no need for General Clauses Act. When you are not having any term which is mentioned in the statute, then you go to the General Clauses Act. Like say, for example, if you have to see the definition of data in the Digital Data Protection Act, then data is defined there. So you don't go to General Clauses Act to find out the meaning of the data, right? Is it clear? Okay. Now, if you see, there is this is another important provision which you find in many of these legislation. So it is not only the same legislation which refers to the definition, but many a times you refer to definition into the coordinate legislations also, or similar legislation or perimaterial legislations also. Like for example, in clause 95 of section 2 of Companies Act, it says that words and expression which have not been defined in the Companies Act can be read from Securities Contract Regulation Act, Securities Exchange Board of India Act, Depositories Act, and will have the similar meaning assigned in those legislations. So you can see Companies Act definition has to be supplemented with definitions from which legislation? 3 legislation it has referred to. And then General Clauses Act will come into picture. So you have to see those legislation also whenever you are seeing an interpretation of company. Now, if we talk about another important term that is called delegated legislation. So delegated legislation basically means that a lot of delegation is done in legislations for making of rules, for making of regulations, right? And the powers are given to the government, like say, for example, power to make rules will be given to the ministries and power to make regulations will be given to the regulatory bodies. Like, for example, in case of Competition Commission, the rules are framed by Ministry of Corporate Affairs. And if the regulation has to be framed, like, for example, general regulation or combination regulation, the Competition Commission of India gets the power to frame the general regulations, okay? And any other regulations for functioning, either it is commitment regulations, penalty regulations, lesser penalty regulations, all these regulations are framed by Competition Commission of India. They have got powers under the Competition Act. So as you are able to see here on the left-hand side, the provision which we have taken from one of the legislation, that is data protection law, you see power to make rules have been given to the central government. Now, in this case, for data protection, I think Ministry of Telecommunication has got the power. So they will be making the rules. And regulations will be made by some authority, like, for example, TRAI or any other body which is designated or nominated for that purpose. In our case, in company law, mostly it is Ministry of Corporate Affairs and the different bodies. Like, for example, in case of Insolvency Bankruptcy Board, who makes the regulations? It is IBBI which makes the regulations, and rules are made by the Ministry of Corporate Affairs. So this is about delegated legislation. One thing you should always remember, that in delegated legislation, nobody has got a power more than the parent legislation. Like, say, for example, no one can make, or say, no one can make a regulation which goes beyond the parent act. Like if a power is given to the NFRA to make some regulations, it cannot go beyond the power which has been conferred to it, or it cannot make a contrary regulation than the law or the act, which parent act which is there. So that has to be taken into consideration very, very clearly. Now, let me move further and talk about these two authorities I've already talked about. Now, let us go ahead and talk about General Clauses Act and definitions. Okay, so in definitions, there are certain things which have been mentioned, and I am going to deal with them one by one. So the first thing is there is a term which is called means and or include. So in many of the provisions in law, you will find the definitions are either restrictive or they are extensive. So the definition clause in definition may be restrictive or it can be extensive. And how do you get that, whether the definition is restrictive or extensive? You read them, and when you find that there is the word includes is there, then you can say that this is a form which is more extensive. And when the word is defined to mean such as and such, the definition is prima facie restrictive and exhaustive. And whenever you say whereas the word defined to declare to include, then it becomes extensive. You can include some more things into it, similar kind of a things into the definition. So here, whenever you find the word means, that means you have to be specific. You cannot include any other interpretation to that term. Whereas when there is a word includes, then you can include some more things along with that, right? So this is how you read it. So when by an amending act, the word include was substituted for the word means in a definition section, it was held that intention was to make it more extensive. Further, and definition may be in the form of means and includes, where again the definition is exhaustive. On the other hand, if the word is defined to apply and to include, the definition is understood as extensive. These meanings of expression means and includes have been reiterated in number of decisions, including the DDA versus Bholanath Sharma. This is the case in which this has been dealt with in detail. So for your understanding, you just see that any provision where you find the word mean, that means you have to restrict yourself in providing an additional meaning to that definition. If the word says includes, then there is a flexibility where you can become more extensive and add certain things to it. It is possible. So let us talk about the examples. Definition of company as given in section 220 of the Companies Act, it states company means a company incorporated under this act or any previous company law. What do you mean by this? This here, you cannot add anything else other than a company incorporated under the act or any other previous company law, right? So you cannot include a partnership firm into it because it says specifically means. Similarly, section 2, subclause 34 of the Companies Act defines the term director, and it says director means a director appointed by the board of the company. So you cannot include a deemed director here. It has to be a director appointed by the board of the company. In another example, word debenture says debenture defined in section 230 of the Companies Act states that debenture includes debenture stock, bonds, and any other instrument of the company. So here you can see it is a definition which is inclusive in nature. It is a definition which is broad. And if you see this particular term has been defined or interpreted in Sahara case, and they have included the optionally convertible debentures, OCDs, OFCDs, as a security, right? So this is interpretation has been provided. Similarly, in case of body corporate or corporation, it says includes a company incorporated outside India. So these are the terms which you are able to see in terms of means and includes. I hope you got a distinction about these means and include. This is mentioned in your General Clauses Act. Let us look at some of more example. So 2 subclause 12, if you see, it talks about executed and execution used with reference to instruments means signed and signature. Instrument includes every document by which any right or liability is or purported to be created, transferred, limited, extended, extinguished, or recorded, right? So this document can be extensive. It can include many types of documents. Now, see, lease means a lease of immovable property and includes also a patta, a kabuliyat, or other undertaking. So you can see wherever there is a term includes, there is a more flexibility provided to include many things into it. But it cannot be completely, alien or a unique thing. It has to match to the things which has been mentioned here. So in case of Nasiruddin versus State of Uttar Pradesh Secretary, this has been discussed, and it said in Bharat Corporation Bank that wherever the expression means is followed by expression and includes, whether with or without additional words separating means from includes, these expressions indicate that the definition provisions is exhaustive. As a matter of statutory interpretation, it has also been held that the expression and includes is an expression which extends the definition contained in the words which follows the expression means. So this is what I was telling you in our previous slide also. Now, many a times there is a confusion between shall and may. So people will say if there is a word shall, it means mandatory, or when there is may, it means not mandatory, or maybe directory or enabling. But this does not happen so easily in law. Unfortunately, it depends on the situation and context, and may can be used as shall can be used as may. So these are all modal verbs, and you can see there are situations in which may has been interpreted to be shall and shall has been interpreted to may. So it all depends on the cases. For example, in Dinesh Chandra Pandey versus High Court of Madhya Pradesh, Supreme Court elaborated on this concept, and it said the courts have taken a view that where the expression shall has been used, it would not necessarily mean that it is mandatory. It will always depend upon the facts of a given case, the conjunctive reading of the relevant provisions along with other provisions of the rules and purpose sought to be achieved and object behind implementation of such a provision, right? So you have to see a holistic view. It is not prima facie on the basis of the written words. You cannot provide the interpretation. You have to basically go into the depth and try to understand what the legislation is trying, meaning, or what is the objective of the legislation. So there may be a situation where may shall be read as shall and shall be read as may, right? So this is what the law says. I hope I don't create more confusion here. You are able to understand what I'm trying to say. Let us take more examples. Okay. So in case of Section 3 of the Companies Act, it says a company may be formed for any lawful purpose by so and so. Now here the word may has to be read as shall, because no company can be formed for unlawful purposes, right? So here it is may be formed. So it is like shall be formed for lawful purposes. So here may is mandatory. A company compliance of Section 3, formation of a company has to be done properly. Similarly, Section 21 of the Companies Act provides that documents proceeding required authentication or contract made by or on behalf of the company may be signed by a key managerial personnel and or officer and the company duly authorized by the board in this behalf. Usage of may shall be read as may. In this situation, you can read may as may. Now, there is another case, Vidarbha Industries Power Limited versus Axis Bank Limited. And this has been decided. And here, it was a matter relating to IBC. And the court said ordinarily, the word may is directory. The expression may admit confers discretion to admit. In contrast, the use of the word shall postulates a mandatory requirement. The use of the word shall raise a presumption that a provision is imperative. However, it is well settled that prima facie presumption about provisions being imperative may be rebutted by other considerations such as scope of enactment and the consequences flowing from the construction. So in case of IBC, the legislature used the word may in Section 7(5)(a) of the IBC in respect of application of CIRP initiated by financial creditor against corporate debtor, but has used the term shall in otherwise almost important identical provision in 9(5) of the IBC in case of operational creditor, and it has been held that may of IBC but different word shall is otherwise this. So, two provisions are intended to convey a different meaning. So you cannot now read may as shall and shall as may in case of section 7 and 9 respectively. So this is what was held in Vidarbha Industries Power Limited versus Axis Bank. So this is the interpretation which one has to give. Okay. So yeah, so this is a very yes. So this is what is a problem, Miss. I am not getting your name. Whatever you have written. So idea is here that when the legislation makes the law, they use these particular terms, and when it comes to the application, when it comes to the problem where you have to actually apply the law, there the issue comes, because every situation cannot be contemplated at the point when the law is being made. And hence, in that situation, many a times court has to give interpretation where may is treated as shall and shall is treated as may. And, and that is why lawyers are needed, otherwise there is no need for lawyers. I hope this provides you some clarity, but definitely there is a confusion around there. Okay. So, yes, Anubhav, I think you are right on your point, but this is what the law is. I hope I hope your suggestion is taken into consideration by the future legislators. When they make law, it is more clear. But I think now, if you will see the legislation nowadays, there is less amount of interpretation on may and shall. So there is no distinction. An example could be this. Like, say, for example, I gave you the previous example in IBC. Here, court said that, okay, fine, if there is may, then it may, and shall, then shall. We are not going into the details of it, because these are the two different provisions, and we consider that if may has been mentioned, then you read it as may. If it is shall, then you read it as shall. Okay, Vidarbha Industries is an example of that. Probably they heard you before. Okay, so I hope this is clarifies your doubt. Okay, now let me move further and talk about preliminary section. So if you see the preliminary section of the General Clauses Act, it says this act may be called the General Clauses Act, and any preliminary section is an introductory part of the law, which generally contains short title, extent, commencement, and the title. Every act is given a title to carve out its own identity. So here we say General Clauses Act, and it is a short law. So Section 2 of the General Clauses Act has been repealed already. I have told you that. Now let us talk about general definitions. So there are certain general definitions which we are going to, take it forward. Now, if we are talking about Section 3, 4, and 4A, Section 3 talks about in this act and in all central act and regulations made after the commencement of this particular law, unless there is anything repugnant in subject or context, these are the definitions. So Section 3 has talked about many definitions. We are going to go into that one by one, right? Here, if you read, it is saying after commencement of this particular act, any legislation which has been made, then you have to refer to that. Like, say, for example, Section 3, subclause 2 defines act. And it says, act used with reference to an offense or civil wrong shall include a series of acts, and words which refer to acts done extend also to illegal omissions. So this you will find at many places. Act not only means, yes, Section 2 is for definitions in every act, but not in this case. In this case, it is Section 3. And in some legislations, it is not Section 2. It is Section 3 or Section 4 or maybe Section 5 also. So it depends on the legislation, but generally in most of the legislation, Section 2 is the definition clause. Like, for example, if you see the Insolvency and Bankruptcy Code, it has got two definition clauses, one in Part 2 and the other one is in Part 3, right? So it depends on that particular situation. Okay, so act includes not only the acts, but it also includes the omissions. So if somebody has not acted upon issue or not acted in consonance with the what should I say, in consonance with the uh, mm, duties which he has, then in that particular situation, that will be also considered as act. Omission will also be considered to be as act. Now, if you see, affidavit is defined, and in affidavit says affidavit shall include affirmation and declaration in case of persons by law allowed to affirm or declare instead of swearing. What is the difference between affirmation and swearing? Anybody? Uh, Affirmation and swearing. So many a times when you say swear is basically with reference to the God, or you can say someone, you are swearing in the name of someone. Affirmation is basically for people who who don't want to take the thing on the basis of swearing, on the basis of God's name or somebody else's name. Like I swear on the name of my mother, or I swear on the name of the God. Uh, Many people want to affirm it. Like they want to say that, okay, fine, I stand by it. So there is a distinction between affirm and swear. So oath, when you say oath shall include affirmation and declaration in case of persons by law allowed to affirm or declare instead of swearing. Similarly, in case of swear, with its grammatical variations and cognate expressions, shall include affirming and declare in the case of persons by law allowed to affirm or declare instead of swearing. So many a times you will see this word is used, person by law allowed to affirm. So there may be persons who are not allowed to affirm, like for example, insolvent, or maybe there is a person who is of unsound mind. They are not allowed to affirm because they are not in sound mind. They cannot affirm. Or maybe a child who is not of a legal age cannot oath or swear or affirm, right? I hope you are able to get this particular point. General Clauses Act also defines month, year, and financial year. Interesting, no? So month is defined, and it says shall mean a month reckoned according to the British calendar. So you are using British calendar. We still use British calendar. Year shall mean a year reckoned according to the British calendar. And financial year shall mean the year commencing on the first day of April. So you see from where it coming, first day of April, it is General Clauses Act. Financial year, you reckon from 1st of April. Now there may be different other calendars also, which is in vogue, but we follow this particular calendar as per section 3, subclause 21 of the General Clauses Act. Now, I think we can take a short break. It is already 1 hour. And if you all agree, then we can just pause for another 15 minutes and then we can go ahead with our provisions further. Okay. Uh, okay. So if you all are agreeing, now it is 7:03. So we meet at 7:18. Okay. See you at 7:18. before we begin and the remaining students join. There is one point which someone brought up, I think Anubhav. Witnesses should be present in swearing. Not necessary. This is not a difference between swearing and oath, or you can say affirmation. It is basically the religious element. You can see if you talk about swearing, it is generally done in the name of a religious deity or a book, and that is called swearing. When you say affirm, there is no religious element involved. In both these cases, whenever you file an affidavit, there is a requirement of a witness. Witness is there to actually witness that you signed on that particular page. If you don't sign, they are there to affirm. If, say, for example, tomorrow the question of that document comes, whether it is an original document or not, the witnesses can be called and asked whether you saw so and so sign this particular document. They will say, yes, this document was signed in front of me and this bears my signature. So this is how witnesses will be. Okay. So I hope you understood the difference between that. There is a question which is about commencement and enforcement. So if you see the commencement and enforcement part of it, the law itself will mention that whether the law is coming into immediate effect after the law has been passed by the president or the approved by the president, or it will come or at a future date. So the law itself mentions that the law will come at a future date whenever it is notified. I gave you an example of DPPP law, that is the data privacy law. Similarly, there were other legislation like Companies Act also got notified on different dates. So that is because those provisions got notified on that particular date. Okay. So this is the distinction. Let us have a quick recap. As you are able to see here, the general definitions we are talking about. And in general definition, we discussed act, we discussed affidavit, oath, swear, because they are related. That is why I have attached them together. Otherwise, if you see in your clauses, they are alphabetically arranged. So it will come later when you read the actual law. Month, year, and financial year we have covered. Now let us move further and talk about the definition of, the central government. So central government has been defined. And if you see here, there are two types of definition given here in this central government. One is before constitution and one is the after constitution. So once the constitution came into picture, the central government is defined as the different, government of the state and, government of administration of part C states and then union territories. This is what it has been talked about. If you look at the different type states, that is part A states, part B states, part C and D states, these are the states which used to be there prior to in the British era, right? So former British provinces they were, and you can see these are the representatives who came in this part A, B, C, D states. Now, after constitution came into picture, this scenario has changed. You all know that how many states we are having. Government or the government shall include both central government and any state government. So this is the definition of the government. Central Act, subclause 7, 3 subclause 7 defines the Central Act. And Central Act, if you look at this, the Central Act shall mean an act of parliament and shall include an act. Reckoned means counted. And the people who are asking questions there about a meaning and all, I would request you if you can use the dictionary, okay? So use the dictionary wherever you find a difficulty in getting an understanding about a particular word. And also for the students who are asking explanation in Hindi, I would, request you that you can go ahead with a dictionary. So have a Google translator along with you. And then simultaneously you can put that particular word. It will give you more additional information also. By this way, you will be able to effectively learn. So please follow that particular process. Okay. Now, let me take you to this definition of Central Act. And if you see Central Act means Act of Parliament, and it basically includes act which is made before the commencement of the Constitution by the Governor General in Council or Governor in those capacity, or even includes an act of the Dominion Legislature or of the Indian Legislature passed before the commencement of the Constitution. So there are three phases before the we got independence, right? So there was India got a dominion status before we were fully independent. So by way of a legislation, India was given an independent dominion status, and then later on we got independence. Before that, it was Britishers. Before dominion, it was completely the British regime. Okay, so there is also a definition of Indian law, and it shall mean any act, ordinance, rules, order, bylaw, or instrument which before the commencement of the Constitution had the force of law in any province of India. So you can see this Indian law has been defined in the General Clauses Act, and you will see that many of the British legislations were applicable to India. However, there were some legislations which were exclusively made for India. So these are called Indian law in General Clauses Act, and we are taking this particular definition further. Then, if you will see, and there are further some definitions like enactment shall include regulations, as I told you before, and any regulations of the Bengal, Madras, Bombay Code, etc. So these regulations will be part of the enactment. Section shall mean section of the act or regulation in which the words occurs. Subsection shall mean subsection. Rule means rule. Schedule shall be the same schedule of the act which occurs at the end of the law. Commencement. When we say commencement used with reference to an act regulation shall mean the day on which the regulation comes into force. And this is done by way of a announcement in the official gazette. Document has been defined, and document will include any matter which is written, expressed, described upon any substance. It will include any letters or figures or more than those, means, and which is intended to be used to be, or which may be used for the purpose of recording the matter. So this is what the document is. So document is not only on a piece of paper. Document can be on a piece of plate. It can be piece of wood. It can be anything. Okay, that will be considered as a document. Even if something is written on a piece of napkin, that becomes a document. So you have to see the definition of document is quite wide. So material does not matter on the what material it has been written, but it has to be written something, letters, figures on the medium, and that has to be taken. Nowhere you can see it is written as it has to be written on a piece of paper or a A4 size sheet, right? So that is a document. Now, expression referring to writing, whenever there is a word expression referring to writing, it shall include reference to all kinds of writing, right? It can be printing through a printer, it can be lithography, it can be photography, and any other modes of representing or reproducing form will be referred to as writing. Okay, so it can be any script, it can be any kind of a pen, or it can be any kind of a language. So that is what is referred to as writing. Now, government securities has been defined, and it shall mean securities of the central government or the state government. And there is an immovable property shall include this. We have already discussed, and I gave you the explanation that when you read it with General Clauses Act, that is benefits arising out of the land has been interpreted in case of immovable property, in case of Transfer of Property Act to include fishery rights, right? Movable property means every description except immovable property. This is a very convenient definition. Registered, used with reference to a document, means registered in India under the law for the time being in force for the registration of documents. So there is a registration law, that is Registration Act of 1908, which provides for the registration mechanism. So you have to get registered a document which is above the value of 100 rupees, something like that. Then there is person, shall include any person or association or body of individuals, whether incorporated or not. So person is a very broad definition. Then there is something which is called good faith. So anything shall be deemed to be good faith if it is done honestly, and if there is a negligence also involved in that, it will be considered as good faith only. Unless there is an intention to do wrong, it will be considered as good faith. Offense shall mean any act or omission made punishable by law for the timing in force. So that is an offense. So any law, any act or omission which has been made punishable by any law, then that becomes an offense. Imprisonment shall mean imprisonment of either description as defined under the Indian Penal Code. Now it should become Bharatiya Nyaya Sanhita. So this change has not yet been made. Probably that will be changed once they notice it. Then section 4 talks about application of foregoing definitions to provisions of previous enactments. So if you will see, these are some of the definitions which they have mentioned, which will be applicable to previous enactments. Like for example, Land Acquisition Act is of 18, much prior to this, 1864. And this General Clauses Act came 1887. So these definitions will be applicable to those laws also which came prior to the General Clauses Act. This is what section 4 talks about. So this is there. Then let us move ahead with section, yes, it is the same. Then general rules of construction. So now we talk about general rules of construction. Let me see whether you have any questions. So if you have any questions, then I'll answer that. Otherwise, we will move ahead with this general rules of construction. Okay, there are no questions. So you can see here, section 5 to section 13 talks about general rules of construction. Let us move ahead one by one. So first, section 6 talks about effect of repeal. So you will find that many a times legislations are made. Laws are new, old laws are repealed, new laws are made. So when the act or central act or regulation made after the commencement of this act repeals any enactment, then unless a different intention appears, where do you find this different intention? This different intention you will be finding in the subsequent legislation. Like say, for example, away and new legislation will come. Let us take an example of company law. So Companies Act 1956 was there, and then thereafter 2013 came out, right? So there are certain interpretations about that which has been mentioned in section 6, and it talks about the repeal, and it says that any repeal or any new law which comes up, presumption will be that it will not revive anything not in force or existing at the time at which the repeal takes effect. Okay. So it will not bring up something new unless there is a specific mention in the new legislation. So you will find that in most of the legislations, there is a repeal and saving clause towards the end. So if you see Companies Act, there also there is a repeal and saving clause. Similarly, in most of the new legislations, there is a repeal and saving clause. So it will mention what happens to the cases which has happened before, or what happens to the situations which have not been covered here. All these situations will be mentioned there. But if it is not mentioned, then you go to the General Clauses Act and see what does it say. So section 6 of the General Clauses Act says that it will not revive anything which is not in force. It will affect the previous operation. So it should not affect any previous operation of the enactment so repealed or anything duly done or suffered thereunder. Like for example, in IPC, there used to be, there will be a provision which was an offense. So if someone did an offense before, and in Bharatiya Nyaya Sanhita, that provision is not an offense. So that particular provision will not go away. Like for example, adultery was an offense under IPC. In Bharatiya Nyaya Sanhita, it is not an offense. So the prior offenses of adultery will not go away. That has to be prosecuted. Okay. Similarly, affect any right, privilege, obligation, or liability. So it will not affect any liability or obligation or a privilege acquired by somebody under the previous legislation, even if it is repealed. Third, it will not affect any penalty, forfeiture, or punishment incurred with reference to any offense, as I gave you an example just now. Similarly, it will not affect any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, forfeiture, or punishment as aforesaid. And any such investigation, legal proceeding, or remedy may be instituted, constituted, or enforced, and any such penalty, forfeiture, punishment may be imposed. So this is what is about repeal. I hope you understood the effect of repeal. So repeal of a legislation will not take away the things which has already happened in the previous legislation. This is what is the, in essence, in broadly, it means. Then moving ahead, let us talk about an example. So I was giving you an example of repeal clauses. This is a IBC, Insolvency Bankruptcy Code, section 243, gives repeal of certain enactments and savings. So here you can see it is mentioned very clearly what should happen in case of a repeal. So it is trying to tell that this will happen, this will not happen, this will happen. And you have to first refer to IBC section 243. If there is no confusion in implementation, you don't have to go to the General Clauses Act. But if there is a confusion in interpretation of this, or there is an issue around here, then you can take assistance of General Clauses Act section 6. Ideally speaking, whatever has been mentioned in section 6 provided here has already been incorporated or brought into action in section 243 of the IBC. I hope this makes it clear. Further, section 6A talks about repeal of an act making textual amendment in act or regulation. And 7 talks about revival of repealed enactments. So there may be a situation where the repealed amendments are brought again into force. And there may be situations, but these situations are not many. These are some, very rare examples. And if you talk about repeal of act making textual amendment of the act, what does it say? It says where any central act or regulation made after the commencement of the act repeals any enactment by which the text of any central act or regulation was amended by the express omission, insertion, or substitution, or any matter, then unless a different intention appears, the repeals shall not affect the continuance of such amendment made by the enactment so repealed and in operation at the time of such repeal. So basically, it is trying to tell that if there is a textual amendment which has been made in the act or a regulation, of that particular repealed act, then it won't make a difference in the subsequent law. Let me, bring this particular thing by way of an example, and section 8 will make it more clear. If you read section 8, it says construction of references to repealed enactments. So if there is a repealed enactment, how do you refer to it? Because what happens is many a times a legislation is referred to another legislation. So if one legislation is repealed, what happens to the legislation in which that legislation is referred to? Like say, for example, if a legislation IBC refers to companies law and company law get amended or repealed subsequently, then what happens to the provisions which were referred to? Like say, for example, under the Companies Act 1956, some provision was referred to in one legislation. Now, Companies Act 1956 is no more. What happens to the provision which has been referred to in that legislation? How do you deal with that situation? So this situation is being dealt with by section 8, and it says that where the law after the commencement of this act repeals and reenacts with or without modification any provision of a former enactment, then references to any other enactment or any instrument in the provision so repealed shall, unless a different intention appears, to be construed as reference to the provision so reenacted. So it is basically saying that in that legislation where Companies Act 1956 was referred, will now refer to Companies Act 2013 equivalent provisions. So you don't have to, even if it is not changed, no worry. But if the referring act is changed, the new legislation of the referring act will be referred to by way of a construction. So this is by way of a practical applicability, that if, say, for example, some legislation refers to IPC and IPC is no more now, so what do you do? Whether you don't implement that provision? No, you go ahead and refer to section 8 and refer to the latest provision which is under the new legislation. This is what is the provision which has been mentioned here in section 8. I hope this gives you that clarity. Let us take an example. In section 115 of JB of the Income Tax Act 1961, for calculation of book profit, and Companies Act 1956 are required to be referred. With advent of Companies Act 2013, the corresponding change has not been made. Then on referring to section 8 of the General Clauses Act, book profits has to be calculated as per the Companies Act 2013. This is what exactly the example I gave you. Then commencement and termination time. This is an important one. So if you will see here, in any regulation made after the commencement of this act, it shall be sufficient for the purpose of excluding first in a series of days or any period of time to the use word from, and the purpose of including the last in the series of days or any other period of time to use the word to. So if you see the example, it will be more clearer. So for example, a company declares dividend for its shareholders in its annual general meeting held on 30th 9/2022. Under the provisions of Companies Act 2013, company is required to pay dividend within 30 days from the date of the declaration of so and so to this. So if you will see in this series of 30 days, 39 will be excluded and the last day will be included in calculating 30 days. So many a times you get a problem-based questions on this particular area. So you will be given a situation and then you should leave the first day and calculate the last day for calculating 30 days. I hope this definition is clear to you. Then computation of time. So section 10 talks about computation of time, and it says whereby any central act or regulation made after the commencement of this act, any act or proceeding is directed or allowed to be done or taken in any court or office or any a certain day or within a prescribed period, then if the court or the office is closed on that particular day, the last day of the prescribed period, the act or proceeding shall be considered as done or taken in due time if it is done. It is basically a simple, formula that if the last day falls on a holiday, you take the next day as your day. Okay, so this is how you look at this computation of time. So if, say, for example, there are continuous 3 holidays, then the last day will fall on the next working day. This is what computation of time talks about. Measurement of distances. Section 11 talks about measurement of distances, and it says, for the purpose of this regulation, distances shall, unless a different intention appears, be measured in a straight line on a horizontal plane. So you can see how specific the law has been, right? So some people are very mischievous, and people want to misuse the law. So what they will do is basically, if it is said that, okay, fine, measure a line, Now, line can be a circle also, line can be a tangent also. So it has been very clearly written here. If you are measuring a distance, it has to be in a straight line on a horizontal plane. So it cannot be. Now, what happens? Say, for example, in case of a distance you are measuring in mountains, probably there has to be an exception to this, because in mountains there is no horizontal plane. In mountains, the distance has to be measured in a different way. So, and that this I observed when I was in Uttarakhand. There, the measurement of land is done in a different way, because their legislation has a different mechanism to deal with it. Because in mountains, if you measure it by horizontal plane, it will be very less. So you have to find out a different way of measuring it. So these are quite interesting, situations. The section 12 talks about duty to be taken pro rata in enactments. So pro rata basis means that if there is a reference to a particular duty or particular some aspect, then if you are calculating for 30 days and you are calculating for 15 days, you have to do it on a pro rata basis, right? So you have to look at it from that particular perspective. Gender and number in all central acts and regulation, unless there is anything repugnant in subject, words importing the masculine gender shall be taken to include females. I think there is a new change in this. Now it includes even transgender, but not in General Clauses Act, but in the IPC they have made this particular change. And the words in singular shall include the plural and vice versa. So there is no confusion on a singular or a plural aspect or on the gender. Wherever they mention the word he, shall mean she and third gender. Now, repeal of laws. So on repeal of laws, we have already seen section 6, section 8. Now, repeal of laws can be done by way of repeal in one of the provisions, or it can be done by way of a separate amending act altogether. So there are a number of laws which have been repealed by the central government now because they have become obsolete or they are not needed. And those repeal of laws are taken under section 8. You have to have a look at it. So if you see section 8, where a later statute incorporates by reference, this I have already discussed with you people. So let us look at the example. Repeal and replacement of Mines Act 1952 had a reference to definition of coal mine as defined under the Mines Act in Coal Mines Provident Fund. And it was constituted as referring to the definition under the Coal Mine Act 1952 in the case of State of Bihar versus SK Roy. Similarly, in Insolvency Bankruptcy Code Amendment, Second Amendment, repeal the Repealing and Amendment Act does not affect the changes brought by these amending acts in the IBC. So that keeps continuing. Now there are some provisions with reference to powers and functionaries. So section 14 to 19 talks about different powers and functionaries. And if you see here, it tells you a situation. You just imagine a situation that there are government offices and you deal with this particular situation that there is a government officer who died in between, or he remitted office, or he has not continued, or new appointment has not happened. Then whether that particular office will remain vacant, or what will happen to that particular official chair. Say, for example, there is a dean of a faculty and his retirement date is mentioned on a particular date, and nobody is coming to take charge of that particular office. What happens there? Or maybe a vice chancellor of a university, what happens there? So these situations are contemplated in section 14 to 19, where they are basically telling what happens in case of a government office there is a power which has been given, and how you confer that particular power and how you deal with that power. What happens when you substitute the function of the person concerned? All these things are mentioned here in section 14 to 19. Now, these provisions basically undermine the administrative flexibility and continuity embedded in statutory frameworks. They are basically designed to address issues relating to succession, delegation, and maintenance of authority within various levels of functionaries, ensuring smooth governance, right? Like, say, for example, one election happens, one chief minister comes, another goes, then the officers should have that continuity. Let us take an example. A municipal corporation is tasked with managing urban development, enforcing regulations, and maintaining civic amenities. So municipal commissioner is the chief executive officer in this case. Now, powers which are conferred to be exercisable to him from time to time has not to be mentioned again and again. So the Act empowers the municipal commissioners to levy fines for illegal constructions. These fines are not a one-time imposition. They can be applied as often as violations occurs, such as when unauthorized structures are repeatedly built in different parts of the city. Similarly, power to appoint includes power to appoint ex officio. So a municipal corporation commissioner appoints an officer as the head of the health department. By virtue of this position, the appointee automatically becomes an ex officio member of the Municipal Disaster Management Committee, and ensuring the health perspective is considered in disaster planning. Another example I will give you, like for example, in universities, the deans are ex officio members of the academic council. So every time, whenever a dean is appointed, a new dean comes, then in that situation, he automatically becomes the member of the academic council. There is no need for him to be nominated. Similarly, if you will see, the chairperson or the president of ICAI is ex officio member in number of committees and boards. So whenever a new president comes of ICAI, there is no need for a specific appointment of that particular person. By virtue of his office, he gets appointed in those particular positions. So these are few examples which I wanted to give you here. Now, power 16 talks about power to appoint include power to suspend or dismiss. This is a very important provision where the commissioner who has appointed sanitary inspectors to enforce cleanliness and waste management also suspends one inspector for neglecting duties, such a failing to address persistent garbage collection complaint in a key residential area. So basically, anybody who has got the power to appoint has also got the power to suspend or dismiss that particular person. Then substitution of functionaries. However, here you have to understand that there are certain situations in which there are exceptions to this. Power to appoint include power to suspend. Like for example, judges of the courts, there is no power because there is a security of their tenure. So though president appoints them, president cannot just dismiss them or suspend them. There is a huge long process which is mentioned for it, like it is an impeachment. You must have heard about the latest issue around impeachment of a honorable justice. So similar, those are exceptions. Okay. So here in general situation, anybody who has the power to appoint has a power to suspend or dismiss. Similarly, there is a provision which refers to substitution of functionaries. So if the commissioner is on a long medical leave, the deputy commissioner steps in to exercise the commissioner's statutory power. So most of the times in government offices, it happens like that, right? So if the chairperson is not there, vice chairman takes into charge. If there is a deputy who takes charge of that particular situation and keeps working. So office work does not stop, it continues. Section 18 talks about successors, and it says when the current commissioner retires, the newly appointed commissioner immediately inherits all powers, responsibilities without requiring any formal transfer. This ensures that governance and administrative functions like addressing encroachments or improvement, etc., are taken into consideration. I am reminded of that particular movie, One Day CM. You remember that? What is that movie? Nayak, I think movie name is Nayak only, where Anil Kapoor was there. So he took charge of a CM for one day, right? So there was nothing required. He just took the oath, and thereafter every machinery which was accountable to the previous chief minister immediately got accountable to him, and he started working immediately on that particular day. So this is what it is talking about. That is, successors. So these are the general provisions under the General Clauses Act. These all provisions are meant for smooth functioning of the offices. Then official chiefs and subordinates. So chief engineer and corporation delegates responsibility to assistant engineers. While the chief retains overall accountability, subordinates carry out day-to-day operational tasks with their specific jurisdictions. These examples basically demonstrates how these principles work together to create a robust framework of governance. It also ensures that powers are exercised effectively, delegated appropriately, and seamlessly transitioned or substituted in the case of changes in personal or unforeseen circumstances. Now, there are provisions relating to orders, rules, and made under the enactment. So section 20 to 24 talks about this, that how do you construct the orders which are issued under the enactments, who has got the powers to include or add or amend to these notifications, who has got the power to make rules, bylaws, what is the power of making rules, bylaws, and how do you continue these particular orders. So section 20 talks about construction of orders, etc., issued under the enactments. And it says that unless the context or there is anything which is repugnant to the subject or context, anything repugnant to the subject or context means anything contrary or anything other than what has been mentioned, have the same respective meaning in the act or regulations conferring the power. So if you will see, let us take an example. The term collector used in Rule 4 of the Land Acquisition Company Rules will have the same meaning under the Land Acquisition Act. So in Subhash Ramkumar versus State of Maharashtra, it was held that notification in common English acceptation means and imply the formal announcement of a legally relevant fact, and notification published in official gazette means notification published by the authority of law. It is a formal declaration and should be in accordance with the declared policy or the statute. Notification cannot be substituted by administrative instructions. So there has to be notification means notification. It has to be notified properly. It cannot be done by an oral instruction or an administrative instruction. So just that is what it is talking about. Then 21 talks about power to issue and include power to add, amend or vary. So whenever there is a power to issue a notification, this includes the power to change that notification, power to rescind that notification, power to amend that notification, right? So in this particular case, Rasid Javed, Supreme Court held that under Section 21 of the Act, an authority which has power to issue a notification has the undoubted power to rescind or modify the notification in the like manner. Similarly, in another case, it was held that power under Section 21 of the Act is not so limited as to exercise only once. Power can be exercised from time to time, having regard to the exigency of the situation. Now, making of rules or bylaws and issuing the orders between passing and commencement of the enactment. So all acts provide some powers to make the bylaws and rules. Then if you will see here, it says that then that power may be exercised at any time after passing of the act or regulation, but rules, bylaws or orders so made or issued shall not take effect till the commencement of the act or regulations. So this happened in case of competition law. So the competition law came into existence or effect on, as I told you, on 20th May 2009. And the regulations which have to be framed or regulations which have to be made have been made by the Competition Commission of India subsequently. However, no regulation will come into effect unless the act comes into effect. So it is important because that is the parent legislation. So while the regulations can be made by the authorities, but that can only come into effect when the act comes into effect. Similarly, Mediation Act. See, for example, Mediation Act has come up. They are framing the regulations, but those regulations can come into effect only when the act comes into effect. So these are some examples of Section 22. Then Section 23 talks about provisions applicable to making of rules or bylaws after previous publication. So this is basically a provision which requires that the law which are coming up, the new laws, have to be published, have to be taken the opinion of the public. So it basically says where any central act or regulation, a power to make rules or this is expressed to be given, then you have to follow the process. The authority have the power of making rules or bylaws. Before making them, publish a draft of the proposed rules or bylaws for the information of persons likely to be affected thereby. So this is what public consultation is about. So you will see nowadays, or otherwise also, everything will be put on the website, draft regulations for public consultation. The publication shall be made in such manner as the authority deem fits. Generally, it will be by the Gazette. And there shall be published with a draft notice specifying a date on which the draft will be taken into consideration. And then the authority having power to make rules or bylaws, where the rules or bylaws are to be made with the sanction, approval, concurrence with another authority. That authority shall consider any objection and then they will approve that particular thing. All these bylaws and everything will be laid before the House of the Parliament for finality. Okay. And once it is published, it will be a conclusive proof that rule or bylaw has been duly made. So publication, final publication in the Gazette is important for giving a legal sanctity to that particular rules or bylaws. So you can see here, this is the notification of these are draft digital personal data protection rules, which has come up 2025. Now this is not yet notified, right? This is a draft notification put for public consultation. So this is how it has to be put for public consultation. Now, whatever consultations are over in this particular matter, and now the rules may be notified in future. Section 24 talks about continuation of orders, etc., issued under enactments repealed and reenacted. Okay. So if you see here, it talks about a situation of the laws which have been repealed and its continuation. And the best example would be the Section 66 of the Competition Act, where they gave powers to different authorities for continuation of the cases which were there under the MRTP Act. So MRTP Act got repealed, but after that the cases which were pending before the MRTP Act, some cases were given to the Competition Appellate Tribunal to be dealt with, and some cases went to the National Commission of Consumer Dispute Redressal Commission, National Commission, and they dealt with some of the cases. So this was made possible by way of a repeal and saving clause, which provided for the mechanism as to how the certain situations will be dealt with after the repeal of the old legislation and coming up of the new legislation. So this is the situation which is being covered under Section 24 of the General Clauses Act. Now there are some miscellaneous provisions which are there in the legislation, like Section 25 to 30. So there will be recovery of fines, provision as to offences punishable under 2 or more enactments, meaning of service by post, citation of enactments, saving of previous enactments, rules and bylaws, and application of acts to ordinances. So you people must be knowing about ordinances. Ordinances are law promulgated by the President of India when Parliament is not in session, and it is a immediate legislation which is a requirement of the day. Since Parliament is not in session, the government gives this particular legislation for the President. President promulgates it as an ordinance. There were multiple legislation which were promulgated initially as ordinance, and then later on it became the act. One can be example of the ordinance could be the farm laws, which was passed as an ordinance, and then later on act, and then it was repealed later on. Similarly, there are many legislation which were passed as ordinances. Now, if you talk about Section 25, it talks about recovery of fines. And it says Section 63 to Section 70 of the Indian Penal Code and the provisions of Code of Criminal Procedure for the time being enforced in relation to issue and execution of warrants for levy of fines shall apply to all fines imposed under the Act, regulation, rule, bylaw, unless the Act, regulation, rule or bylaw contain an express provision to the contrary. This is what recovery of fines says. Section 26 provision talks about provision as to offences punishable under 2 or more enactments. So whenever there are punishment in act or omission constitutes an offence under 2 or more enactments, then the offender shall be liable to be prosecuted and punished under either of those enactments, but shall not be liable to be punished twice for the same offence. So it is a constitutional guarantee. Basically, Constitution of India under Article 20 talks about double jeopardy. Okay, double jeopardy. So you cannot, this is called rule against double jeopardy, and you cannot prosecute a person for the same offence twice. Okay, Article 20 subclause 2 of the Constitution specifically states that no person shall be prosecuted and punished for the same offence more than once. So in the case of state of MP versus V.R. Agnihotri, it was held that when there are two alternate charges of the same trial of the Prevention of Corruption Act, the fact that the accused is acquitted in one of the charges will not bar his conviction. So it may happen that the similar fact of situation gives rise to different types of offences. That is a different case. So Article 20 subclause 2 interpretation, there are a number of case laws. If you are interested more, you can read on this. But it is general, as a general principle, it is saying that when there is an offence punishable under 2 or more enactments, you take up as one, punish. You cannot punish the person for the same offence twice. Then meaning of service by post. This is an interesting one. Those were the days when service was done by post. So see, whenever there is a court case, there is a requirement of a service. So first thing which has to be done in a court case is whether notice has been issued or not. So in a civil litigation, service is very important. So how do you do the service? As per the Code of Civil Procedure, service has to be done by way of handing over personally, or by way of a speed post, or there is something which is called substituted service in CPC. Substituted service can be by way of a publication in the newspaper, or it can be pasting the notice on the house of the person concerned. These are the different modes by which the service will happen. Here, section 27 talks about service by post. So it is saying where any central act or regulation made after the commencement of this act authorizes or requires any document to be served by post, whether the expression serve or either the expression give or send and any other expression is used, unless a different intention appears, service shall be deemed to be effected by properly addressing, prepaying, and posting by registered post a letter containing the document, and unless the contrary is proved to have been effected at the time at which the letter would have been delivered in the ordinary course of the post. So, service is complete as soon as you do a registered post. So, once you put the registered post, you are not responsible whether it reaches the person concerned or not, and that is how the court will take it as a service. So, these were the rules under this particular provision. Nowadays, service is done in number of modes. You people are all aware. Now, service can be done by way of an email. Service can be done by way of a video conferencing. It can be done by multiple modes nowadays. So, Code of Civil Procedure Order 5 provides for several modes of service. So, there can be different modes of service. I have already told you about that. In the case of this United Commercial Bank versus Veemsen Makhija, a notice when required under the statutory rules to be sent by registered post acknowledgement due is instead sent by registered post only. The protection of presumption regarding serving of notice under registered post under this section of the Act neither tenable nor based upon sound exposition of law. So just try to see if the rules say registered post acknowledgement due, then just a general registered post will not work, because acknowledgement due means that somebody will receive it and your acknowledgement will come back to you. So this is what was held in this case. So rules are stringent. Once rules are mentioned clearly in the law, then you need to follow that particular rule. You cannot just circumvent it. This is what it is trying to say. Let us look at another case. In Jagdish Singh versus Nattu Singh, it was held that where a notice is sent to the landlord by registered post and the same is returned by the tenant with an endorsement of refusal, it will be presumed that notice has been served. So even if the tenant has refused, but tenant need to communicate to the landlord that there was a notice which came, I have refused it. So you cannot just refuse a notice and say that, okay, fine, it is communicated. So even a refusal of a notice is considered as communication. So many a times people say, okay, I will not take the notice, so that is amounting to service. If you did not take the notice, that is on you, because still you will be responsible because a notice came to you, you denied it. In another case, Vandana Gulati, it was held that where notice sent by registered post to person concerned at proper address is deemed to be served upon him in due course unless contrary is proved. Endorsement not claimed, not met is sufficient to prove deemed service of notice. Then there is another important provision, that is section 28, which talks about citation of enactments. So it is saying that wherever you are going to cite a law or enactments, then how should you cite it? So it is saying basically that wherever you are reference to such act regulation, any enactment may be cited by reference to the title or short title conferred thereupon or reference to the number and the year thereof. An enactment may be cited by reference to the section. So it is basically telling you that how do you cite the reference. Like for example, section citation. The provision of section 5 of the Companies Act are relevant to corporate restructuring procedure. Here, this refers to a citing an enactment. So here what are you citing? You are citing the Companies Act 1956, section 5. So using the title and for particular provision, section 5. General citation. Many a times you can just mention Income Tax Act 1961 or rule made under Income Tax Act rules 1961. Incorporation of provision. Many a times you cite the whole provision is incorporated. So this kind of a citation can also be there for citing the enactments. Now, section 29 talks about saving of previous enactments, rules, and bylaws. So we have already actually dealt with this. So it says basically it avoids retroactive disruption by maintaining the stability and enforceability of rules and bylaws from repealed laws. This ensures continuity in governance and reduces uncertainty, upholds the past action conducted under earlier legal frameworks. So this is about repeal and saving clauses. So any saving provisions has to be construed accordingly. This is 30, talks about application of Act to ordinances. And as I told you before, the ordinances can be promulgated by the President as per section Article 123 of the Constitution. And whenever there is an ordinance which is promulgated, that will be considered as the law. Okay. So under the Constitution, the power to make law rests with legislature. However, in cases when Parliament is not in session and immediate action is needed, the President can issue an ordinance. An ordinance is a law and could introduce legislative changes. The Supreme Court has clarified that legislative power to issue ordinances is in the nature of emergency power given to the executive only to meet an emergent situation. An example of immediacy can be seen in the ordinance passed in 2011 to give IIT Kanchipuram the status of an institute of national importance, so the students could be awarded their degrees on completion of their course. So these are some of the examples of ordinances. I gave you another example of farm laws. So these are the provisions under the General Clauses Act, and some provisions may seem to you as very technical in nature, and many a times you may be feeling in your mind that what is the utility of this particular law, because we are already reading the legislation which are broad enough, it has got everything into it. So whether there is a requirement of General Clauses Act, but you will be surprised to note that till date General Clauses Act is referred to in the Supreme Court arguments, and lawyers would bring that time and again. Recently, in the case of Enforcement Directorate director whose tenure expired, and he was given an extension. So the recourse to General Clauses Act was taken in that particular decision also. So maybe I'll pick up that particular decision later sometime, maybe in our next class, and we can discuss that again. But now I would like to open the floor for any questions, and I would take questions, any questions you have, any one of you. Please utilize the chat box. You can use the questions, or I would request the coordinator, if you can enable their mic, they can ask the question on mic also. There's no problem. Yes, you can utilize the chat box or you can utilize the mic, whatever you want. Yes, it is interesting, but you need to read that provision. So law becomes interesting only when you read the provisions. So it is important for you to read the provisions. If you read the provisions, it will be interesting for you. Definitely, yes. Revive anything, not enforce means what? Where are you reading, Tanisha? Can you tell me which provision you are reading, which section? Someone asked about 328. Let me check. 328. 328 talks about India. So it says India shall mean so and so, right? So it is talking about India in the British period. It is talking about India during the Dominion, and it is talking about India after the commencement of the Constitution. So the legislation in all these three period will be considered as reference to India, right? So it is not only the India after independence, but it is also India before independence. This is what it is talking about, right? Three phases. One is the British period, the other one is the Dominion status, and the third one is after independence. Okay, just a second. Which period will give an question powers? In this, you have to just see General Clauses Act. You can refer to General Clauses Act. You can get it anywhere. So there's no problem. Okay. If you just search for it on India Code, General Clauses Act, you will get this legislation free of cost. You don't have to purchase it. That is bare act. But if you want to have some case laws and all, you can purchase of EBC or Universal, whichever you want. 29. Okay. Section 29 is basically, it is talking about Section 29 is talking about saving from previous enactments, rules and bylaws, right? So it is saying the provisions of this act representing the construction of acts, regulations, rules or bylaws made after the commencement of this act shall not affect the construction of any act, rules, regulations made before the commencement of this act. So it is basically talking about that General Clauses Act came in 1897. There were multiple legislation which were prior to 1897. So it is saying that any construction which has happened to the legislation prior to General Construction Act will not get affected because of the coming up of the General Clauses Act. So in effect, if you look at Section 29, is of not much relevance in the present context. Okay. Is it clear, Astha? Okay. Next, we have got effect of repeal of Section 6. Yes. So effect of repeal, Section 6, I gave you examples also. So whenever there is a repeal of any legislation, the repealed law will not completely go away, right? So the repealed law, any action which has been taken in that repealed law will continue. Anything which has been done in that repealed law will continue, right? So, and in most of these situations, the new law will provide the mechanism as to deal with the repealed law. So it will tell you that what has to happen, what will happen in those situations, how you are going to deal with this situation of repealed law. Like, for example, if you see Section 644 of the Companies Act 1956, it provides for repeal of the enactments mentioned in Schedules 12, the old Companies Act 1913. Now, if you look at Companies Act 2013, it talks about repeal of the provisions of Companies Act 1956. But there are certain provisions or any actions which have been taken in 1956 Act will continue. And it will not completely become obsolete. Any action which has been taken by authorities will continue. That is what is the provision talking about. Okay. Any other questions? I would request the admin if you can provide them the mic access, they can ask the questions live also. There is no problem. किसी को और कोई क्वेश्चन पूछना है तो पूछ सकते हैं आप. Abhishek has an interesting question, and it is actually a reflective question. Uh, he says, I wonder if everything is clear in law, then why there is a case of fight? If already all things are clear in law and all judgments of judge is according to the law, which is written and available for all to read, then why there is a confusion? The confusion is not created by law and judges. Confusion is created by people because people are not satisfied. They have a dispute every time. Okay. So it is like that. That's a good question, Soumya. You have asked how to remember technical provisions. So for them, you have to do a mind mapping kind of a thing. Okay. So prepare your notes and link it with a graph or a chart, then you will be remembering it. Otherwise, you will forget it because you cannot remember all provisions. If you remember it with examples, it will be more easier for you. So in all the, I will share these slides with you. I have given examples. So remember the provision along with examples. So it will be easier for you to remember. General Clauses Act is anyways a bit of a technical, topic. Yeah. Yes, Asta, you are right. So under Section 6, if there are cases which have been already brought in under the previous legislation, that will be dealt with under the previous legislation only. Unless, to the contrary, unless the law provides otherwise. Like I gave you an example of MRTP Act. When Monopolistic Restrictive Trade Practices Act was repealed, at that point in time, this did not say that the provisions of MRTP Act will continue. The MRTP Act provisions got repealed immediately. There were about 50, 55 or 60 cases pending under MRTP Act. So the government provided a mechanism to deal with those cases. They said some cases which are at the investigation stage will go to the Competition Appellate Tribunal. They will deal with it directly. 50 cases came to the, which were at the prima facie stage, came to the commission, and Competition Commission dealt with that cases under the Competition Act, not under MRTP Act. And some cases relating to the UTP went to the National Commission, that is Consumer Forum. So there may be differences, there may be mechanisms which have been provided in the new legislation. Say, for example, this is not provided in the new legislation, then you go back to Section 6 and have a look at it. One thing which I told you in the beginning is that if the legislation, main legislation provides for everything, you don't go to the General Clauses Act. General Clauses Act is required only when the main legislation which you are referring to does not provide for something. Okay. So this is a mechanism which you need to understand very clearly. So General Clauses Act is a second resort. First, you look at the main legislation. Okay. I hope this makes it clear. Yes, repeal of provisions is different than deletion of provisions. Deletion of provisions and repeal of provisions and deletion of repeal of provisions is basically when you are talking about repeal of provisions, it is a legal term. When you are talking about deletion of provisions, there is nothing called deletion of provisions in law. It is deletion is a general term. That is the distinction between these two. However, in effect, if you look at it, it means the same. So, repeal of provisions, when we say repeal of a provision, it does not mean that it is completely scrapped from the law. It remains in the law. It is a repealed provision. It may happen that subsequently this repeal provision is also notified by the government. Okay, fine, it is revived. That may also happen. Okay. So, repealed provisions always remain in the statute. Anything which is passed by legislature once remains in the statute unless it is repealed. Once it is repealed, that means it is no more in force or no more in statute book at that point in time. But it is a English, it is a general question whether it is deletion or repeal is the same thing. Technically, yes. Legally, no. Okay. Any other questions? Rajveer, Companies Act provides KMP cannot hold more than one office in a company. Uh, but General Clauses Act provides singular means plural. These are two different things altogether. So singular means plural means what? Singular means plural means basically if at any place it is mentioned one in number, you can, if the context requires, then you can consider it as more also. But that does not mean that specifically when a directors have been given a power, responsibility to hold only one position, they can hold many positions. These are two different things. Don't get confused and club these things together. Okay. Any other questions? Fine, you can type the questions. I'm here. So if you have any questions further, you can utilize it. Chat box. Let me check the admin portal once. Okay. Okay. So general means plural. I'll give you an example. Okay. So motor vehicle law requires that every owner of a motor vehicle shall ensure its registration. Okay. Now, say for example, this motorcycle is owned by joint owners. Two partners of a firm own it. Now the responsibility is not only on the one owner, but both the owners, right? So that is what it is saying that the words in singular will include plural and vice versa. Okay. I hope this example clarifies your idea. Okay. So in case there are no questions, we can close the session today. Next session, which we are going to discuss, is interpretation of statutes and okay, substitution of functionaries, section 17. Okay, I'll explain to you. Section 17 basically talks about, yes, it talks about substitution of functionaries and it says, in any central act or regulation made after the commencement of this act, it shall be sufficient for the purpose of indicating the application of law to every person or number of persons for the time being executing the functions of an office to mention the official title of the officer at present executing the function or that of the officer by whom the functions are commonly executed. So basically, if you are seeing, like for example, you want to address an application in ICAI, so you can address to president, you can address to secretary, you can address to any officer, generally who is dealing with this particular matter, right? So this is what it is trying to tell you. So even if you address is, say for example, it is required that you address to president and it is addressed to secretary. That does not mean that it will not be taken into consideration. Similarly, similar kind of a provision you will find in RTI Act, Right to Information Act. So Right to Information Act makes it explicit that even if the application reaches to a wrong office, they need to send it to the right office. This is what is the requirement under the RTI Act. But that is a specific requirement. But Section 17 generally tells that in an office, whosoever is the responsible person to whom the thing should be addressed in normal course, and the application has been made in a normal course similarly, it will, irrespective of the fact that who is in that particular office, it will be entertained. Like say, for example, if you write an email to the PMO office, then whosoever is there in the chair, it is immaterial, right? So the bureaucrats may change, but the office remains the same. So that office will entertain it, irrespective of the fact that it is addressed to X or Y. Say, for example, in my university, the vice chancellor is Professor Jaswal, and now if he's not there tomorrow, then if someone addresses an email to the vice chancellor, or say, for example, I am the dean and I took the office from my previous dean. So if a letter comes in his name, I cannot say that I will not entertain because it is in his name. It is basically in the name of the office. I hope this clarifies. Okay. Registered post acknowledgement due is a situation where you are having a registered post, you send it by way of acknowledgement due. So there is an extra charge which you pay, and whenever that registered post is delivered, there is an acknowledgement which a letter comes back to you as an evidence that the letter has been delivered. That is registered post acknowledgement due. And if the provision says that you need to do the service by way of registration paid acknowledgement due, and you have done it only by way of registered post, then you have not done the compliance of service. That is what the provision has said. Okay. So I think we are done for the day. Now I would request the tech support to close the session. Thank you, everyone. It was a wonderful interaction with all of you. Looking forward to see you on 7th. We are discussing interpretation of statutes. I would also request you read this General Clauses Act thoroughly, all the provisions. And if you have any questions, you can bring those questions in next session also. I will address them while interaction. Thank you. Have a nice evening, all of you. Bye-bye. Yes. Good night. Bye-bye.